I don't understand. You have you've never completed your high school education. You have no driver's license, no job. And with your criminal history, you're not exactly a great role model for your children who you have custody of none of.
I have custody of Caden.
Who's in custody himself, right?
Yes.
Right. In the state of Ohio versus Chelsea Teagarden. Ms. Teagarden is before the court with her counsel, Mr. Kidd. Ms. Tranter, on behalf of the state of Ohio, we're here for sentencing. There was a pre-sentence investigation. Mr. Kidd, you've had an opportunity to review.
Your Honor.
Ms. Tranter, anything on behalf of the state?
Your Honor, just to, in addition to our discussions in chambers, there was is a restitution request in this case for the court's information, $4,198.74 for car repairs, damage done to the vehicle. The victim being Jesse Carter.
All right. Anything else?
Nothing further.
Mr. Torek, anything from probation?
Nothing further, Your Honor.
Mr. Kidd.
Your Honor, in regard to Ms. Teagarden, I know it's been a rocky period of time for her. She has made some real efforts. She's had some real challenges as well. Your Honor, we know what the recommendation of probation is. Yeah, we're supportive of that recommendation. I've talked to her about the 1 to 5 assessment as to her need for treatment. Not sure what that meant or where it came from, but she very much knows that she does need treatment. I think she's communicated that to the court through letters, that she has sought some sort of treatment program at the coach or otherwise, wherever the court might be. Your Honor, she's never been to prison before. This last failure to appear actually wasn't a failure to appear, but the revocation of her bond. She was dealing with her son, who had a significant charge as a juvenile delinquent in Butler County. She was trying to manage that to some extent, try to spend some time with him, and she simply did not provide the priority to her own case that she knows that she should have done. Your Honor, she knows she came in, that she tested positive. She knows she has a drug issue.
I even wrote him in my P.
And you'll have a chance to talk to the judge as well. But we are requesting that she be placed on community control, that she be able to follow the recommendation of probation. So that's what we're asking. I know she wants to talk to you as well.
Ms. Teagarden, anything you want to say?
Yes, sir. When I was released for the PSI, my son was also on PSI, and I really thought I could handle both of them at the same time and got overwhelmed. When Mr. Brown asked me to come in to see him, I got scared because I couldn't get a ride the first day that he wanted to see me. And the second day when he called me, I just didn't answer because I was scared that he was going to lock me up because I missed the first day. I just didn't come because I wanted to be there for Caden and his court dates. And because I'm all he's got. But now that he's sentenced, I know he's doing 6 to 9 months. And he'll be released at the end of November, beginning of December. And I just want to be a part of his rehabilitation as well as mine. And I did say in my PSI that the coach had evaluated me and told me that I could probably benefit from treatment. And I would like to go to treatment or have the opportunity to please go to treatment before going to prison.
Ms. Teagarden, this always confounds me when someone says they know they need treatment, and here we are, this case has been pending for some time, and yet you have never sought treatment. I don't know what, if you, ma'am, please. Is there something else you want to say to me? Then say it now.
Yes, sir. They came to evaluate me, not this time, but the last time I was in here, because I reached out to peer support to ask for the coach to come see me.
Okay, and then since that time, you had been released from the county jail, correct?
Yes, sir.
Did you engage in treatment when you were released?
I was dealing with my baby's PSI.
Okay, and you see, that's my point. You had an opportunity, if you wanted treatment that you now are telling me you desperately need. You could have. It's like, what are you waiting for? You waiting for me to order it? I don't understand. You've never completed your high school education. You have no driver's license, no job. And with your criminal history, you're not exactly a great role model for your children who you have custody of none of.
I have custody of Caden.
Who's in custody himself? Right?
Yes.
Right. All right. So you just proved my point. Ms. Teagarden, I gave you 3 opportunities on pretrial. The last one was disastrous because you not only didn't show up, didn't do anything, knowing that I was going to sentence you in a few weeks because I released you on February the 9th, the day that you entered a plea. I gave you an opportunity to prove to me that you, in fact, could comply with the rules and orders of the court. And you didn't do it. And not only did you not do it, didn't show up for your interview, didn't show up for your assessment, didn't follow the rules of your supervision. On top of all, is there something else you want to say?
I did my assessment. I did go to him the first time that I was supposed to go to him. I only didn't go the second time.
Okay. You didn't complete your assessment. That's what you're making my point for me.
I did it. He did
Ms.
it.
Teagarden, I'm done. You also, on the last time, tested positive for methamphetamine, amphetamines, and MDMA, correct?
Yes, sir.
All right. Court's considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevance, seriousness, and recidivism finders. The court does find that you are not amenable to community control and that prison is necessary to fulfill the purposes and principles of sentencing due to your extensive criminal history, your failure to respond to any of the court's conditions and your pretrial supervision. So at this time, the court is going to order you to serve 9 months in prison. You have 80 days jail time credit. Ms. Tranter, did you give me a number for the restitution?
I did, Your Honor. I can give it to you again, though.
Yeah, we would object to that, so we would request a hearing on restitution.
How soon can we set that?
I'm not sure because the victim is out of state, so I'd have to see when he can make arrangements.
All right,
to
set
do
the
that.
restitution for hearing. Other than the restitution, the court does find that she's indigent for the purpose of other fines, costs, or financial sanctions. You're also subject to a discretionary period of post-release control, which means when you are released from prison, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can be provided to you. Ms. Tranter, is there anything else?
No, sir.
Mr. Kidd?
No, Your Honor,
All right,
thank
that's
you.
all. Thank you.
And there it is, the final decision, prison time. After reviewing her history, her behavior during pretrial, and her failure to follow through on opportunities for change, the judge concludes she's not suitable for community control. This case highlights a powerful reality in the justice system. Second chances are real, but they come with expectations. When those expectations aren't met, the consequences escalate quickly. It's not just about what you say, it's about what you do when given the chance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.